Okay. Um, Let me just introduce myself first. My name is Quinten Cups. Let me see if I can figure out how to mute everyone here. I know that noise is going to bother some people. If you're just now joining, if you could mute your device for me.
Can you say your last name again, please?
Yes, my last name is Cups. Cupps. Hold on one second here. Oh, there we go. Okay, so can everyone still? I'm assuming everyone can still hear me. Someone in the video, if you want to give me a thumbs up. Okay, good. All right, so I went ahead and muted everyone. I finally figured out how to do that. You should be able to unmute yourself if you need to. But what I'd like to do, because right now we have 80 people on the call, and thank you all for joining. Um, I would like to still try to make this somewhat interactive as we go through, because I have found in all the years that I've done this that no question is a bad question, and there's probably 10 other people on the call that might have that same question you do. And so what we can do is if you're on your computer, there's a chat feature that you can use. It should be above the screens where you see people's faces. Feel free to chat to us, post a question on the chat, and I'll try to review that periodically and answer those questions. I'm not going to try to ask very many questions because it just might. I think it's going to be too hard to get that interaction. But if at any time you feel like you have a question, please don't hesitate to interrupt me. Just see if you can unmute your audio and just feel free to ask the question, and I'll try to answer it. The goal today, I think I've got a. Let's see here. Did that work? Here we go. So the goal today is it's we like to call this class a board member boot camp. It is intended for anyone obviously who's a board member or is maybe thinking about running for the board. And it is as I mentioned before, it's not going to go into a lot of, I guess, depth legally on all the different variations of statutes and legal claims that might come up. I wanted to give more of an overview of things that, as a board member, things that you should know and things that you can do to try to avoid getting the association or yourself into trouble. And I draw a lot of this from experience that I have in representing associations for 12, 13 years now, and seeing all the different claims that can be brought up and ways that owners try to interpret the statutes. So just as way of the introduction here, the name of our firm is Vial Fotheringham. Some of you on this call, we may represent your community, I'm not sure. But we are a full service law firm, full service HOA law firm. This is all we do. We represent homeowners associations. The picture on your screen is a map of where our offices are located. The states that are highlighted without the blue dots, we have attorneys licensed to practice in those states. So we cover most, if not all, of the Western United States, which makes it nice in the collections realm. If people try to flee Arizona and flee their creditors, if they go to one of these states that's in orange, we can just pass it along to that attorney licensed there, and we can follow them and still try to track them down. But those are where our offices are on the blue dots. And as I mentioned, we handle everything that comes up in an HOA, condominiums, planned communities, whatever it might be. As a legal issue comes up, we have someone that has experience to handle that. So that was just a little selfish promotion here. So let's get into this, and we'll try to get through. I don't think this will take longer than 2 hours, and hopefully shorter. But I'm happy to stay as long as there are questions, and we can go longer than that. So 5 things every board member should know, and this again goes back to the summary that I gave of what I'd like to try to cover. As a board member, it's important that you understand your documents, and we'll talk about that, sources of law. It's also important that you understand what your fiduciary duties are and what that means. We will also talk about practical duties that you have and common statutes that you will see come up probably more than others. I do want to spend some time talking about how you enforce your documents as a board. And then lastly, we'll talk about some tips to help you avoid trouble or potential liability. So first, let's talk about some sources that if you're not familiar with, you need to be. If you are, there's probably more you could learn. Now, I was told ahead of time that we have a nice mixture of those living in condominiums and those living in planned community, single family style homes. So that's good. These first two sources, it's just going to depend on where you live and whether or not one of these two statutes applies. Now I have, if you can see on my screen, we have these statute books. I think most law firms are producing these now, and it just sets forth all the statutes that govern your association. I don't think I have enough right now to send all 90 of you, but if you are interested, I'm sure you could reach out to Michelle and we can try to coordinate something. But those statutes are important for you to understand. Now, you may not understand them fully. I will say that a lot of the attorneys, we probably don't understand them fully and we disagree on how they're interpreted. But generally speaking, it's important to understand that what they do, what they require, and what's in there. And so if you're in a single family community, Planned Communities Act statute applies, and the Condominium Act also. I will say if you live in a townhome, I don't know if any of you on the call live in townhomes, that could be either one, and that's something you'll have to figure out and discuss with your attorney and your manager as to whether or not you're a condo or a planned community. I will say the easiest way to tell the difference is just find out who owns the common property. If it's owned by the association, then you're a planned community. If it's owned by if there's an undivided ownership interest with the owners where they share ownership, then you're a condominium. So it just kind of depends on how that's structured. But it's important to know that so you know which statutes to look to. Now, I'll venture to guess that most of you on this call, your community is a nonprofit corporation. I have seen very few in Arizona that are not. But assuming that you are, there are provisions of the Nonprofit Corporation Act that might also apply to you as well. So it's good to be familiar with that statute and what that involves. And sometimes you look to that for notice requirements, maybe certain board requirements, actions without a meeting, which we'll talk about later. There are certain provisions in there that may not be covered as clearly in the first two statutes. So you need to look to that statute. Now, when the attorneys get involved, we as attorneys will look to case law. I will tell you, Arizona is not as active when it comes to case law as some other states. You go to California or to Florida, they are much more active, a lot more people willing to pay to sue and to appeal those cases to where you actually make case law. But we do have our fair share here that apply. And if you ever ask one of your attorneys to give you a legal opinion, there's a good chance that attorney will cite to a case to help support the argument. But that's what we'll do. If we ever have to go to court, that's what the statutes and case law are, what we're going to rely on to try to make the case for the association. So those are important. Now, other laws that may come into, there are other laws that may come into play. And one of those sets of laws that seems to be happening a lot more than other would be the Fair Housing Act and fair housing claims. Now, we're not going to go into a lot of detail about that. That could take up a whole nother hour talking about fair housing. But that is a set of statutes that you might need to be familiar with, and your attorney can certainly help you with that. Let me just look. There was a question on the chat here real quick. I'll just read this real quick. So it says our bylaws specifically say that the board must establish a budget for determining annual fees, and that any increase in annual maintenance fees must be voted on by the membership. So the statute, this is a good question. It talks about what does the statute say when it comes to raising assessments, budgets. I will tell you the Condominium Act has a specific statute on budgets. The Planned Community Act, not as much, but the Planned Community Act does address raising your assessments. And what it says is that you are able to raise your assessments up to 20% without a vote of the membership, unless your documents require some lower percentage. So if your documents say that you can only raise it 5% without a vote of the owners, then you're stuck with what your documents say in raising assessments. But if it's silent on that, you can go up to 20% under the Planned Communities Act. And then the Condominium Act, you're going to want to look at your documents for raising those assessments. But if you are in a condominium, be aware of the budget requirements and whether or not your owners have to approve the budget. And that's probably as much detail as I want to go into it for right now for this class. But that is a very good question that you want. It says here you had an opinion from your attorney, but and it's a condominium, so you might want to look at that a little further. But just know the Condominium Act does talk about your budgets and then your bylaws. If they're more strict than the statute, you would follow your bylaws. Okay, so sources of law. I mean, it's not the most exciting stuff, and you may not want to actually take the time, but it is good to be familiar with it. Now, this slide here, this is where you really need, as board members, you need to. Whoops, I skipped ahead here. This is what you really need to be familiar with as a board member. You really need to understand your governing documents. Now, they could be referred to as project documents, community documents. There's all kinds of names that I've seen used. But you really need, as board members, you really have to understand what these say. And so these aren't necessarily in order of importance, but close. And I will say, let's start with the plat map. And I tried to give a little description on the handout that was circulated. I hope everyone got a copy of that. I will make, just as a sidebar here, I will make this presentation available to anyone who's interested, and the handout. If anyone didn't get a copy of it, then please let me know, and I'll make sure you get a copy of it. But I tried to give just a little synopsis of what each of these documents mean. Normally, if we were teaching this class in person, I'd have a back and forth with the group to get your idea or your understanding of what these documents are. It's just not as practical on a Zoom meeting like this, or a GoTo meeting. But let me just explain briefly kind of the plat. The plat is kind of that forgotten document that a lot of people look over. A lot of times I'll get a community will sign up with us for us to represent them, and I'll ask either the board or the manager to send over their governing documents. And 9 times out of 10, I'll get the articles, the CC&Rs, the bylaws, maybe the rules, but very rarely do I get the plat map. And the plat map is very important. As most of you probably know, that the plat was the document that your developer created and filed with the county to basically set up your community. It sets forth the lot lines. It's the document you look to find out where the easements are located. It will establish where your common area is, where the tracks are, things like that. Now, if you live in a condominium, your plat can be really important. I've seen many communities where the definition of a unit, what is a unit, what are the common elements, sometimes it's not as clear in the CC&Rs, but it'll say it on the plat. It will describe and define the boundaries of a unit. So don't overlook the plat. Now, you may not be able to read it. I mean, if your community is 30 years old, your plat probably isn't very legible. You may have to break out the magnifying glass to actually read any of the language on there. But don't ignore the plat, and don't forget about the plat map. Maricopa County and most of the other counties have gotten pretty good about putting all this stuff online and improving the image quality. So most of the stuff you can find online now, and it's pretty good quality to read. But look at the plat. Articles of incorporation. They are those are the documents that created your association. When your developer decided to build the community, the developer has to file the articles of incorporation with the state to establish your nonprofit corporation. And those articles are important too, because they will lay out, sometimes they will discuss terms of the board, how many people are going to be on the board, how long they're going to serve for, whether or not they're staggered terms. It will talk about indemnification, which is very important. If there's a mistake that's made, is the community obligated, is the association obligated to indemnify each one of you as board members? That you want to look for that in your articles, and sometimes it'll be in other documents, but a lot of times it's buried in the articles there. So that will be important to understand. Now, I think the most important document that you need to know, frontwards, backwards, in and out, is your declaration, the CC&Rs. The question I always pose is what purpose do the CC&Rs serve? Why do we have CC&Rs? And the answer that I'm looking for is that the CC&Rs is the document that governs the property. It's the document that tells owners what they can and can't do with their property, and it's the document that tells you as board members what the association is obligated to do with that property, or in trying to enforce the documents. So very, very important document there. And I did have a question here on amending your documents. That's a great question, and it kind of depends. You might hear that word a lot from attorneys. It depends. But whether it's your declaration or your bylaws, they should have a provision towards the end. One of the last, second to last, maybe section, where it talks about amending. And it's going to set forth a percentage requirement. And that's a percentage of owners that have to vote on it. And you have to meet that percentage for the amendment to pass. For planned communities, there's a statute. It's 33-18-17 in the statutes that gives you a little more guidance about amendments, and it makes it a little bit easier because now you can use what are called written consent forms rather than a ballot where you have to have a meeting in 50 days. You can spread it out a little bit longer to try to get those votes. But almost every time it's going to require a percentage of your ownership. So 75% of the owners, all owners, have to vote in favor of an amendment. And for the condominium, same thing. Usually it's a minimum of 66 or 2/3 votes of the owners. I will tell you, be careful. So ARS 33-1227, so 1227, that is the statute that governs condominium amendments. And you have to be very careful with amendments. And this is something you really need an attorney to help you with, because there are certain amendments you might try to do in a condominium that will require 100% of your owners to approve. So be very careful if you want to amend your documents. I guess the takeaway here is please get your attorney involved, because there can be some mistakes made that can have long-lasting effects in your community if you do it wrong. But it is possible. Sometimes it may not seem that way if you have a large percentage, a large community. But you just want to look to your documents to see how to amend that. So your declaration governs the property. Now, the declaration is recorded. And what do I mean by that? It's recorded. It's submitted with the county recorder's office, whatever county you're in, and they record it. They give it a recording number. They make it an official public record. The reason you have to do that with CC&Rs is because it says it runs with the land, meaning that it attaches to the actual property. And if it's not recorded, your CC&Rs are not valid. So I would be shocked if any of your CC&Rs were not recorded. But that's why you do it, because it involves governing the property. So if you compare that to your bylaws, which is next, what do we have bylaws for? Bylaws have nothing to do with the property. Bylaws govern how the association is to operate as a nonprofit corporation. So the bylaws, this is your kind of handbook as a board member, is to be familiar with your bylaws, because this will tell you what you should and shouldn't do, and how to operate, how to function, how anything to do with the board is going to be found in your bylaws typically. Now, you may have some carryover into your CC&Rs, but your bylaws are your main document. Now, you'll notice bylaws are not recorded, and that is because they have nothing to do with the property. It's just a governing document that governs the community. So you don't have to record your bylaws. There's no need to. And I tell you, I would recommend not recording your bylaws. Now, rules and regulations, policies. That's the other group here of documents. Um, rules are a tricky thing. This is something where I see communities get in, and boards especially, get into trouble, where they want to create a bunch of rules because maybe your CCNRs are silent on a certain issue. And so we're just going to create a big stack of rules and we're going to force the owners to abide by the rules. And that can work, but you have to be very careful that you only create rules based on the authority that is given to you in the CCNRs. And what I mean by that, if you look in your CCNRs, it's usually towards the middle of your CCNRs, maybe Article 5, 6, 7, something like that. It usually has a general governance kind of section, and it will talk about rules. And it will say the association has the authority to create rules. But you have to look after that and see, what do those rules apply to. It may say that the association has rules to govern the common area, but it may not say anything about the lot or the unit. And if that's the case, your rules, you can't create rules that govern the lots. Your authority is limited to your common property, usually what the association owns, or in a condo, just that common area. So I've had clients before where they send me their rules, and it'll be a 30-page set of rules, and they didn't have the authority to govern basketball hoops on the lot, or some shed that might have been built. And so you got to be very careful with your rules that you don't go too far with them. But rules can be effective as long as they're done properly. They're good for if there's a section of your documents that maybe is vague, needs to be interpreted. You get your rules together, and you can try to interpret your CCNRs through a resolution or those rules. And they don't have to be recorded, and the reason why is they arise out of the CCNRs, and the CCNRs are already recorded. So therefore, the rules would go with the CCNRs and be part of it. So there's no separate need to record your rules. But just be very careful, like I said, with the rules, that you don't exceed your authority. The other most important thing with rules is they cannot contradict your CCNRs. So if your CCNRs say one thing, you cannot pass a rule to change that, because that's, in a sense, amending your CCNRs, and that's not how you amend. If your CCNRs are silent, in my opinion, if you create a rule to address something that's not addressed in your CCNRs, I don't think that's contradicting your CCNRs. I think that's okay, as long as it's within the authority. But if there's any specifics in your CCNRs, be very careful with your rules that you do not contradict them. Now, I have a question here that it was how often should your documents or bylaws be reviewed, either by the board or by an attorney? That really, it's there isn't a bright line rule on this on how often. If your community is pretty new, within the last 10 years, maybe 15 years, my guess is your documents are pretty good. And if you haven't had them reviewed ever, maybe you have someone take a look at them, because laws do change, situations change that maybe weren't contemplated by the developer. If your documents are older and you haven't had them, I mean, I would say maybe every 5-10 years is a good to have someone just look at them, because things, like I said, things do change. Now, you don't have to amend your documents every time the law changes. If there's a law that says you can no longer do X, Y, or Z, and your CCNRs allow you to do that, you don't have to amend your documents to bring it up to speed. You just follow the law. Now, if you're in there amending your documents for something else, if I'm doing that project, I'm also going to recommend changing it to bring it up to speed with the law, because we're already in there doing it. But it doesn't make sense to me to amend your documents just to conform to a new statute that was just passed. Just because the cost and the likelihood of success on an amendment, it doesn't, for me, it doesn't seem worth the time and money just to change it for a law. But it is a good idea to review them periodically and have someone maybe take. A lot of times too, what will happen with your documents is you may ask an attorney to give you a legal opinion on some random issue that's happening in your community. And just because as attorneys, that's what we have to do, is look at your documents. They may, just by doing that, come back to you and say, hey, I happen to be looking at this provision and I saw what is a little bit concerning to me about your documents. Maybe we ought to think about amending to help out your community. So it may just happen by chance that your attorney's already in there looking. So, it's not something that you as a board have to do all the time as a review. So, one other question here. Let's see. Where's my mouse here? So one of the questions goes back to the amendments of the CCNRs, and the statement was it does, but the owners are not participating. We can't get a quorum for an election either. That's unfortunate, and there really is no other way to amend your CCNRs right now for that situation. And that's the tough part, is if you have that apathy in your community where no one cares, or you're not going to get that response, you may never be able to amend. And unless there was some extenuating circumstance where you could get a court to order that a certain provision was need to be changed for some emergency situation, I think maybe that's an option. But short of that, without owner approval, you're kind of stuck with what you have. And you do your best to try to educate the homeowners and get them to participate and why it's important that we do this. But there's not a whole lot you can do if you can't get involvement. Let me see here. This is an interesting one. We've been around since 1975, and lots of changes have occurred due to technology. Our CCNR say we can't work from home. We had to change that with COVID. I'm not sure what that means, that we can't work from home. I don't know if you're referring to a board meeting that can't be from home. Oh, I see what it's. Oh, I see what it is. It's employment, where you can't have a business out of your home. That's probably what you're referring to. Yeah, and that we'll get into that issue a little bit later when we're talking about enforcing your documents, because the association might have the opportunity to grant what's called a variance, or maybe make an exception to certain situations. So that's kind of on a case-by-case basis. But let's maybe we could table that and come up a little bit later with it. So any other questions here? I'm going to move on to the next part, but kind of the takeaway, like I said, the documents are something that you can't ignore. You have to be familiar as part of your duty as a board member, which is what we're going to talk about on the next slide. Part of that duty is being very familiar with your documents. And if you don't want to take the time to read your documents or try to understand them, you probably shouldn't be on the board, because it exposes yourself to potential liability. If you're not acting within the confines of the documents, you could get yourself in trouble. So one more question here, and we'll move on to the next slide. Arizona may pass recreational marijuana laws this fall. Can you comment on what, if anything, an HOA can do to mitigate against noxious odors wafting over the walls? All right, so this is actually a question I've received multiple times this year for whatever reason, probably in anticipation of this. I would venture a guess that most of your CCNRs have language that prohibits owners from being a nuisance, from allowing some sort of nuisance to occur on their property, whether it's a loud noise or odor. Now, this question I'm going to assume is from a planned community based on coming over the walls into another lot. It might be a condo, I don't know, but the idea of a nuisance, it can be tough in Arizona to prove that, because what you might think of as a nuisance may not rise to the level of something that's going to seriously alarm or annoy another homeowner. So we might be able to politely or with some sort of demand ask this owner to be respectful of his neighbors and stop being a nuisance because of the marijuana smoke. But if that person ignores that, I will tell you this: I don't know there isn't any case law on this yet. I don't know what a court would say if you tried to go to court and try to sue them because they were a nuisance to their neighbor. I think that might be a tough lawsuit. Now, the other issue this comes up is in condominiums, where you have units that are sharing a wall and someone's smoking in their unit, or someone's smoking on the balcony and the smoke is traveling up. I've had to fight this fight too, and I've made demands on owners they can't smoke. We've tried to even pass policies in some of my communities where they can't smoke on their balcony because it's interfering with the use and enjoyment of the other units. Now, in the ones that I've done that, we haven't had to go to court over it, so I don't know what a judge would say. But there usually is a provision in your CC&Rs, which is where it would need to be, that prohibits this type of noxious activity. But like I said, it may not rise to the level of a nuisance as has been defined by different cases in Arizona. So it just kind of depends, and it's very fact intensive, depends on what the situation is. So, all right, let's talk. This is probably the most boring part of the presentation, so bear with me. It's the legal aspect here of what is a fiduciary duty. Now, all of you on this call who are members of a board, you have what's called a fiduciary duty. You as board members are tasked with overseeing maybe a small, maybe a large community, your budget. You may have to deal with a lot of money. Maybe it's not very much money, but you've been entrusted by your election to the board. You've been entrusted with these funds. You've been entrusted with doing or I guess running or overseeing the community. And the standard that is placed on each one of you is this, as you see here on the screen, this duty of care and duty of loyalty. That's part of this fiduciary duty. So the Nonprofit Corporation Act, and sometimes your articles of incorporation will talk about this, but this Nonprofit Corporation Act will talk about this duty of care and loyalty here. And really it kind of boils down to this. As a board member, you have an obligation to act in good faith. Now, we could try to discuss what does that mean in good faith. You know, it's good faith versus bad faith. It can turn on certain things. You know, what do you have specific obligations to do certain things as a board member? Are you targeting a certain homeowner because you don't like that homeowner? Okay, that gets you into the realm of bad faith. So it's what's in the best interest of the community, or I'm sorry, of the association as a nonprofit entity. That's going to be your good faith standard there. And you see on the second part here, with the care an ordinary prudent person in a like position would do an exercise. So that's when a judge is presented with this claim that an owner or a board member is acting in bad faith or in violation of the duty, that judge is going to look at this standard of good faith, is going to look to the standard of what would an ordinary person do in a similar situation. Would that other ordinary board member have done this? Or is what this board member did, does that cross the line into bad faith? So at the end of the day, your job as a board member, this should be the thought that you have with every decision you make, is what we are doing, is what I'm voting on in the best interest of the community. And if it's not, if you have question about that, then step back and think about it, maybe have discussion. But you need to do what's in the best interest of the corporation, the association. Now, this claim, I'm actually defending a case right now where the association, they didn't name any of the board members personally, thankfully, but the association it's alleged that they violated this breach of, or that there's a breach of this good faith, of this duty, and this fiduciary duty. And so homeowners that want to bring this claim, it's their obligation. They have the obligation, the burden of proving that you acted in bad faith or didn't follow that duty. You're presumed to have do it. Now, some of you may have heard, or may have been, it may have been explained to you that you need a legal opinion, or you need to talk to an expert. And you may have heard of this. It's called the safe harbor rule. Safe harbor can be thought of as a bubble that is dropped down over the board, and it protects you against liability. Now, I'm going to say this, but I don't want everyone to jump off the call and go resign tonight from the board. But board members can be sued, and in really bad situations, they can be held personally liable for certain things. I will tell you this, that most of you, I would say almost every one of you, this will never happen to you. It's not something you need to necessarily worry about, but it should be in the back of your mind that when as long as you're acting in the best interest of the association, relying on experts when you need to, you're going to be protected from these sorts of claims. And so when someone says that you need to get a legal opinion or you need to talk to an accountant, it's for your own protection. It may cost some money, but I'll tell you, it's worth that expense to give the association and yourself protection from liability. So if you're not sure on something, if there's a legal issue, then I would recommend you consider it, and considering relying on those experts. That's why most of you you guys work with Vision as your management company. That offers you protection as well, because Vision, that's what they're trained to do, to help manage, and you can rely on their advice as well. So just remember that to rely on experts when you need to, and act in the best interest of your community when making those decisions. Let me see here. Okay, what are the options if a board member is not upholding their fiduciary duty? Renee, I'm going to ask that we hold that question to the end of the presentation. I have a whole 4 or 5 slides on addressing that exactly, on what you can do in the event that your board member is not upholding his or her fiduciary duty. And then the next question: can a board member be sued for asking a vendor for a quid pro quo for services? Yes, and we're going to talk about that here in a minute. I think it might be. Okay, I think it's the next slide after this. We're going to talk about these conflicts of interest. But just some practical terms here for your fiduciary duty. Remember, it's not about what you want as a board member. Okay, remember, it's what does the association need, what is in the association's best interest. And sometimes you have to check those personal interests at the door, because they may conflict with what's best for the community. So you need to be careful with that. You cannot exceed your authority. This goes back to what we talked about with the documents. If you are acting outside of the authority of your documents, there's an argument that you're breaching your fiduciary duty, and you will see that in a lawsuit, that would be the claim, that the bylaws or the CC&R say this, and board members did this, and it runs afoul of your authority. So be careful. That's why you've got to know your documents. Protect confidences. One of the duties there, this duty of loyalty, I'll say, to the community is you're looking out for the community, looking out for the association, and not your own interests. This kind of goes to this question about the quid pro quo. There are certain things that you have to keep confidential, and we'll talk about that a little bit later too. But there are certain items that have to remain within this inner circle of the board and maybe the manager and your attorney. Things that should not be shared outside of that circle. And if you do share that, if you do breach that confidence, that, to me, in my opinion, that is a breach of your fiduciary duty. And if it leads to damage to the association, you could absolutely be held responsible for that. So be very careful with the stuff that needs to remain confidential while you're on the board. And even after you're on the board, you need to maintain that. And then lastly, treat all homeowners fairly and equally. There's actually case law that talks about this standard. And what does it mean to treat homeowners fairly and equally? Well, you need to treat them the same way, no matter what they're doing. And one easy way that you can do this is by enacting certain policies. Now, I've seen some of the stuff that Vision managers help their communities with. Some good policies are out there, and you should definitely have them, whether it's a collection policy, an enforcement policy, something that you can rely on for every single case so that you don't veer off of that and treat someone differently. It's a very common claim that we hear. It's selective enforcement, or the board is treating me unfairly. They gave me a fine for my trash cans, and all my neighbors had their trash cans out after mine. Well, first of all, you don't know what we did to the other homeowners. But two, if we have a policy in place, we're following that policy. That's our response, is that this is the policy that we have, and we're following it, and we followed it in your situation. So if you don't have an enforcement policy, a collection policy, things of those nature, talk to your manager, and let's get you some policies in place to help with that. Now, some of the stuff on why it's important, and we've already kind of talked about, but this idea of setting the framework and a standard for a board. This is your standard. This is your standard of conduct while on the board that you need to abide by. It's your duty. It's your duty to the community. And if it's breached and the association's harmed, you could be held responsible. Now, I mentioned earlier the indemnification. Unless you've acted grossly negligent or intentionally acted to harm the community, you're going to be indemnified by the association or in the insurance. So if you get sued, there should be protection there. But if you step over that line and purposely try to harm the community, there could be ramifications for that. So last part here on fiduciary duty is the conflict of interest. And this is really important. There are 3 statutes that talk about conflicts of interest for communities. You need to really pay attention to the first 2 here, depending on what type of community that you live in. And both of these statutes say the same thing. I think they're verbatim the same. And what it says is that if there is any sort of arrangement, agreement, contract, any sort of decision that the board is going to make, if one or more of the board members or their close family members, and what I mean by that would be children, spouse, or parents of your so in-laws, and I just had this happen in another community when they kind of learned the hard way. But if any one of those people might benefit financially from this decision, that is a conflict of interest that you have to disclose. And at an open meeting of your board, you would disclose where this decision is being made. You would announce to the community, hey, I have a conflict. Here's my conflict. I'm just disclosing it. And that's your obligation. Once you've done that, you've met your requirement under the statute. And the statute says that you could even vote at that point. You can still participate in the vote if you want. Now, just because the statute says that you're allowed to vote, it's usually our advice, at least in this firm, that best practice would be to announce the conflict and then just kind of take a step back and let the other board members deal with it and not participate in it, just to maintain that full transparency and separation from the issue. But if you do vote, as long as you've announced the conflict, you're okay. Now, the most important part about this is what happens if you don't? What happens if you just try to keep it secret and hidden, thinking it's not a big deal? And I had this happen in a community just 2 weeks ago, where a deal went through for a vendor, and come to find out after the fact, one of the board members, it was an in-laws company, and nothing was disclosed. And the statute's very clear on this. It says if that happens and you do not disclose your conflict, the contract that you sign is void and unenforceable. So that's going to put you in a really sticky position, because on the one hand, as a community, you now have a contract that's void. You can no longer enforce that. You shouldn't be paying any money towards it as a community. On the other hand, you have a vendor who certainly didn't agree to that, certainly didn't agree to having his contract voided out. They're going to demand payment for the services if they've been rendered, or maybe they're just a monthly service, whatever it might be. They're going to they could demand payment. And so then you're left in this really tough spot of who pays for it, what do you do? And there isn't a good answer for that. And what could happen if you're not careful is this could be a fiduciary duty issue where now you as a board member, you may have to step to the plate and help figure this out financially. So be very careful with conflicts of interest. If there's ever, if there's a question that it might be a conflict, or if you're trying to get this little quid pro quo as a board member for the services, first of all, don't do that. But second, if there's a conflict and you think there might be one, you got to announce it in an open meeting, and that will protect the community. Does the conflict of interest apply to a board member's friend? Now, the statute does not go as far as to say a friend. It is limited to family members. However, that's a great example of where it still would be advisable to announce a potential conflict, even though the statute doesn't say it. I would still recommend that you just announce it, because remember, as long as you announce it, you can still vote on it. You can still make the decision as long as you've announced it. So even if it is a friend of the board member, I would still, if I'm that board member, I'm still going to announce, hey, this is my friend. I know him, a great company. I'd recommend him, and I think we should discuss it. And that way it's been announced that there's a potential conflict. So great question on that, great example. What if you discover the conflict months or years after the work is completed? Very good question. The statute does not talk about the timing of this as far as when you discover that a conflict was not announced. There may or may not be a statute of limitations on this. I'd have to look at that a little closer. If it was 1 or 2 years where a statute might run on this, it might be longer. But if it's 4, 5, 6 months down the road, it could still be an issue. And now it becomes worse because now you've paid 5, 6, 7 months worth of services that never should have been paid. So that's actually worse if this happens that way. So again, I can't stress enough on conflicts of interest. I've handled these cases and have seen board members step in it. So just be very, very careful, tread lightly, and make sure you announce any conflict. All right, let's talk about some practical duties here. We're going to focus a couple slides here on board meetings. Now, some of this, like I mentioned before at the beginning, some of this may be just kind of a review. Most of you, I'm sure, know this already. I still think it's valuable to go through the exercise of just talking about it. Maybe you'll pick up on something that you weren't aware of before. But let's talk about, and we're not going to talk about your annual meetings. This is just board meetings. These are your regular board meetings. If you have a question about annual meetings, you can ask it. We'll just talk about board meetings for this. There is a statute. Let me get my book here. I think I put it on the handout here. No, I didn't. So ARS 33-1804 is the condominium statute, and then I believe it's 33-1248. I'm sorry, 1804 is the planned community. 33-1248 is the condominium statute. And I will say that of all the statutes that are out there, I really think these are probably some of the most important ones that you need to know in and out as board members, because this is what you do as board members. You have these meetings, and you need to make sure that you are following the open meeting requirements when you're in this discussion or when you're having these discussions, because it's very easy to get tripped up on this. So, notice requirements for a regular board meeting. This is the regularly scheduled board meetings. It is a 48-hour notice requirement, and again, when you have management, they know this stuff. They're going to help protect you on this, and so they know what kind of notice to give. But they're going to give 48-hour notice. Now, the statute says that this is not something that has to be mailed to all the owners. It just has to be posted in a conspicuous place. So if you have a clubhouse, maybe it's posted there. You might have some signs at your entrances that mentions when the board meeting is going to be. Nowadays, most communities have websites with their management companies, and it'll be posted there for everyone to view. So as long as you've done something along those lines, your notice is going to be fine. Notice requirements to directors. The statute doesn't talk about that. Sometimes documents will talk about giving notice to the other directors. So you want to look in your bylaws for that, if there is some sort of notice requirement to directors, and how much notice has to be given. But the key there to this one is the 48-hour notice requirement. So keep that number in mind. So with your board meetings, okay, agendas. You are required in your board meetings to have an agenda. The agenda can be your friend, and it's something you should rely on as board members. So what goes on the agenda? Well, you're going to talk about and approve the minutes from last meeting, and you might have follow-up discussions about old business. Then you're going to have new business. Some of you may have an open forum for your homeowners. All of that should be spelled out on your agenda, and the key is to stick to your agenda. And this has a couple benefits. One, probably most importantly, is you retain control of your meeting. I have been to quite a few meetings where board members and the board, for whatever reason, they have an agenda, but they're quick to just jump off the agenda because homeowners want to talk about some other issue. You have to remind them this is a board meeting. It's not a homeowner meeting. Homeowners are invited to attend. They can participate during certain times, but this is your meeting. You are tasked with having to do certain things that are done at a board meeting. You need to get those things done. And so stick to your agenda. And if it's not on the agenda, someone wants to talk about it, maybe it's not part of the open forum, just say, hey, it's not part of the agenda tonight. We appreciate the input, and we can stick it on the agenda for next month, but we're not going to talk about that tonight, and then you move on. So it can help maintain control of your meetings and hopefully keep your meetings to a reasonable time, so you're not there all night. But stick to your agenda, and remember, the agenda does not have to be circulated to the owners ahead of time. It just has to be made available at the meeting. So just keep that in mind as well. It does not have to be circulated ahead of time. Now, videotaping, I'm not sure how many of you like to tape or video or audio tape your meetings. There was a change in the law a couple years to this requirement. It used to say that the association was not permitted to prohibit videotaping. It could try to establish some rules on how the videotaping was to take place, but it could not in any way prohibit the videotaping. So owners could show up, videotape the meeting, and do with it what they want. I believe it was 2, maybe 3 years ago, the legislature felt the need to amend that and created some new language. And that language now says that still sort of the same idea applies, that they want to allow for recording. But if the association records its own board meeting and has an official camera that's set up to record, you can prohibit the other members from recording, as long as you have an official recording that is then made available to anyone who wants an unedited version of the meeting. Then you can tell other people that you're not to record. We have the official video, and we can make that available. Now, most of my clients don't go through the hassle of recording. They don't want to pay for it. They just don't feel it's necessary. We do have a couple associations that have had a lot of problems in the past with particular homeowners, and for their own safety and for I guess maybe protection against potential liability, they felt the need to spend the money and record every meeting. And they've actually hired a company that comes in and sets up quite a big display, and then they record all their meetings. So it really depends on your community, what you can afford, what you need. Good question just came up though about what about recording virtual meetings. So this whole thing with COVID has created a huge gray area in this area of the law, because no one anticipated something like this happening, where you were going to be forced to have virtual meetings, forced to social distance, forced to not meet in person. A good example is the annual meeting requirements, where you have to give a ballot, where you have to allow for voting in person. And we could talk about that if you want, but those are the type of things. So what about recording virtual meetings? Well, I would say your virtual meeting, you are probably the host, and like we're recording this meeting right now, if you're recording this, you could say that's your official recording of the meeting, and you could tell someone else not to record. Now, how is someone else going to record a virtual meeting? I mean, I guess if they want to stick their camera up and record the screen. I'm not very tech savvy. Maybe there's a way to do it. But I'm not sure you have to worry too much about virtual meeting recording. But it's a fair question. It might be something that you have to do. And I just, there was a follow-up here. They're recording the virtual meeting on the app. So I don't know how you're going to stop someone from doing that. You could ask them, look, we are recording. No one else is allowed to record, but unless it somehow tells you that there are other people recording, I'm not sure on the app if it does. You may not be able to prevent that. But again, is there a problem with someone recording a meeting? You know, I've always looked at it. As long as you're following the law, as long as you're being respectful, I don't think there's anything to worry about if someone wants to record the meeting. The open portion of the meeting. So let's see. So a good question here. It was asked, what about virtual meetings such as Zoom? Some of our owners take exception to not being able to attend a meeting in person. Great question, and very common question. I have fielded this question many times in the last 3 or 4 months. There is nothing that requires you to meet in person for a board meeting. In fact, it talks about in the statute having teleconference meetings. The only requirement is that the homeowners have to be in a position where they can hear and participate on the meeting or during the meeting. So I've seen this before where some of my clients, this is before COVID, they were all out of town, and the manager set up a phone conference at the regular meeting site. All the board members called into the meeting, and homeowners were able to participate there in person, but the board wasn't there. Same sort of thing. you have a Zoom meeting, you're going to invite them. They're attending really in person to the meeting. So I know they want to meet in person, but again, this is a board meeting. This goes back to my comment before. This is not their meeting. If the board decides this is how you want to meet, that's your decision, and you can do that as long as you're following the other requirements of the open meeting laws. So I have fielded that question many times with angry homeowners who don't think that the virus or the pandemic is very serious and want to meet in person and take that risk. That's great, but it's our meeting. We're going to dictate how we meet. So just keep that in mind. In voting out a board member, can that be done in a board meeting or executive meeting? What venue do you deal with personnel issues? Now, this raises a couple questions, I guess. In voting out a board member, if we're referring to removing a board member, hold that thought. We'll talk about that a little bit later. If we're talking about just the regular election, that's not done at a board meeting. That's done at your annual meeting of your members. And if you're dealing with personnel issues, maybe you have an employee, that's all done in an open board meeting, but it can be, part of it could be an executive depending on what you're discussing. And in fact, I think we have a couple slides coming up. We'll talk about that a little further. Just to move on here, another part of your board meeting, some of you may feel something may happen in your community that you believe is an emergency. This is another recent change in the law. If it's something, this is the key here. If whatever you're dealing with is something that can wait for 48 hours, then it's not an emergency, and all you need to do is just get notice of a board meeting and discuss it in 48 hours. If it's something that really cannot wait for 48 hours, the statutes do say that you can have an emergency meeting where you don't have to provide notice, and the board can meet, make the decision. Then you would want to ratify that at your next meeting, just to explain what happened, why there was an emergency, what the situation was. Get it on the minutes at your next meeting. But the key there is if it truly cannot wait for 48 hours, and that's usually something like a flood, a fire, something to that effect, then hold your emergency meeting and then just talk about it at your next regular board meeting. We just talked about telephone conferences already, so I'm not going to go into that in much more detail. Just remember that the homeowners who are part of your board meeting, they have to be given a chance to participate in the meeting at some point. Now I will talk, so let me just mention that real quickly. There's nothing in the statute that requires an open forum for your board meetings. Most of my clients have it, and there's nothing wrong with that, to give owners a chance to talk. But if you don't have an open forum, you're not violating the law unless your documents require you to have an open forum. And I'm not sure I've ever seen a set of bylaws that requires an open forum. And so there might come a time where if maybe things are contentious and you just need to get some business done, and you really aren't interested in opinions about certain things for that particular meeting, that you just take the open forum off your agenda. But remember, before any decision is made, you have to, after the motion is made and it's seconded, before you vote on it, you have to open it up for discussion from the members that are on the call with you or in person with you. And you can limit how long they speak. You can limit how many number of people are able to comment on a particular item. But you have to give them that chance to speak before you vote on the decision. And that's a common mistake I'll see, where they just run through the agenda items, they vote, and they move on, and they don't ever give the owners a chance to speak. Now, some will say, hey, we're going to let them speak in the open forum, but I think the intent of the statute is as the decisions are being made, to allow them to speak. All right, let's talk a little bit about open. I did mention this a little bit, but your board meetings are open to the members. They are allowed to attend, and you cannot prohibit them from attending your open meetings. Now, if they want to designate a third-party representative, they can do that in writing, and then that person should be allowed to attend and speak. Now, notice on here, it's owners meeting. Owners are allowed to attend, and that doesn't include tenants. I'm not going to say that it's a good idea to just exclude tenants. I mean, if you want tenants to attend and voice a concern, maybe that's something you do. But owners cannot be prohibited from attending an open meeting, the open portion of the meeting. I did mention this already, reasonable time restrictions and stick to the agenda. Just good practice to help regulate the time of your meeting and the efficiency of your meetings. Now, I don't usually like to put a lot of words on the screen, but this is quoted from this is the Condominium Act here, but it's the same thing in the Planned Communities Act. This is the only statute in these statutes we've talked about where there was a policy statement made by the legislature. They felt it was important enough to remind communities that the idea here, the presumption, is that your meetings are to be open to the members. And I think there was enough going on in the community, in this industry at the time, to suggest that there were too many boards that were doing stuff in secret. They were keeping things from their homeowners, just doing things on the side, weren't following the law. So they made it very clear, if you take the time to read this statement, that if there's ever a question about whether or not something should be conducted in open, you should do it in open. And it's the idea that this is the policy that we have to keep in mind when we're interpreting statutes, interpreting decisions, that things need to be in open if they're supposed to be in open. Having said that, there is an opportunity to close your meeting, as you know. You can close your open meeting at any time during the meeting, or you might be holding a separate executive meeting. Again, this is all spelled out in your open meeting laws that we talked about. But this is one of the most common violations I see month in, month out of my clients making when it comes to the open meeting laws. It's discussing stuff in an executive session meeting that should and has to be discussed in an open meeting. So let's talk about the 5 things, the 5 topics you're allowed to discuss in an open meeting. And then I'm going to give you some examples here of common mistakes I see. So these are the 5 from the statute. First is your attorney-client communication. Anytime you're discussing a legal opinion, you've got your attorney there, you're talking about that attorney-client privileged information, that is protected communication that should not be disclosed to the owners. And that's something that you really should be doing every time in an executive session meeting. If you have pending or contemplated litigation, so that's a lawsuit has been filed, or you think that a homeowner is going to file a lawsuit, or you think you might file a lawsuit against an owner for some reason, all of that can be discussed in executive session and really should be. Personal health or financial information of an employee of a contractor. Now, of a member or an employee of a contractor. So first, let's talk about members. That's talking about your owners. This is why you go into executive session for your collection discussion. This is why any other health information is discussed in executive. It's to maintain that privacy. I had a community recently that had a board member that felt it was in the association's best interest, despite our advice to the contrary, to go around at community events and actually approach owners who are delinquent and in front of other owners talk about, hey, I saw that you were delinquent last month. Thanks for bringing your account current, or something along those lines, and making it very public of who was delinquent in the community. Please don't do that. The statute, if you read the statute, it actually says that all 5 of these items may be discussed in executive. It doesn't mean you have to, but my advice is that there are certain things that you really need to be discussed, you really need to handle in executive, and they must be, and that would be attorney-client privilege information and this personal information about a homeowner. That stuff really should not be aired out for the community. I've seen communities who want to post a delinquency report on the community bulletin board, or put big red flyers on a home to signify they're delinquent. I mean, crazy stuff that really you shouldn't be doing as a community. So be very careful with the confidential information, especially the personal information of a homeowner. So a question here, what can be done when a board member brings up things in open session that was discussed in executive? Well, that's a great question. And how do you prevent? I mean, there really is no way to prevent that from happening. You can educate, you go to trainings like this to understand that shouldn't be done. What I would recommend if that happens is to gently or forcefully remind, not forcefully, but sternly remind the board member, look, We're not going to discuss that in this meeting. That was discussed in executive, and we're not going to discuss that any further and try to move on to whatever you were discussing before. And if it becomes a situation where the board member is going to continue to do that, you do have the option. You could vote, make a motion to shut the meeting down and adjourn the meeting. That might be an option that you have. And you may just need to educate this board member that what he or she is doing, remember the fiduciary duty obligations, and we have to maintain those confidences. So that's a tough one. And but I have seen communities adjourn their meetings when stuff gets a little bit out of control. Now let me mention here the second part of the third one, and then the fourth option, talking about job performance or personal information about employee. Now you see in job performance and the other one, it's the employee of a contractor. So this is a common issue that comes up, and it could come up in a situation where most of your communities do not have employees. Some of you do, if you're big enough. Maybe you have an on-site staff that your employees. So if you want to talk about their information or their job performance as an employee, that's executive session worthy. Now, you've hired Vision Community Management. You may have hired a landscaper. You've maybe hired a law firm as a contractor, an independent contractor for the association. Remember, they are not the employee. The company itself is not the employee. If you want to talk about the performance of a particular employee of the management company, an employee of the landscape company, that's allowed in executive session. But if you have gripes about the contractor itself, if you want to change contractors for whatever reason, that is not executive session material. And I see that happen all too often, where they'll talk about bids for a landscape company, management company, attorney, whatever it is, and they do it in executive. And that is an open meeting discussion that needs to happen in open. So keep that in mind when you have that discussion. There's certain things that you cannot put into executive. Lastly is a member's violation appeal. If you've sent out a violation letter and imposed a fine, if you want to discuss their appeal of that fine, you can do it in executive. But keep in mind, if the owner demands that their appeal be heard in an open meeting, you don't have a choice. You have to put it into open. So keep that in mind too. If someone makes an appeal, if they want it in open, they get that right. Lastly, this is a recent change within the last couple years that you need to be aware of, and I'm sure this is how most of you are handling this. But before you go into executive session, you have to do one of two things. Either right before you go into the meeting, if you're at your open meeting, you have to announce to the members the statute that you are relying on to go into your executive session. You can't just say, technically speaking here, the way the law is written, you can't just say, we're going to go into executive now to talk about maybe some collection stuff or a lawsuit. You need to actually state the statute that you're relying on. And it's either 33-1248 with one of the subsections or 33-1804 with one of the subsections. But you need to state that. Now, the other way you can do that is in the notice of your meeting. You can put open meeting will be held at 6 o'clock. At 7:30, the executive meeting will be held pursuant to ARS 33-1804 A1 and 2. Whatever it is that you're discussing, you would put that on there. Now, I have seen many communities put it on their agenda and nowhere else. And on a technical level, that does not comply with the statute, the way it's written. Now, is it okay? Maybe. Is someone going to gripe over that? I don't know. If all you're doing is on the agenda, I would try to get the other things involved, whether it's your meeting notice or announcing it at your meeting. But if you do your executive session first, you can't announce it, right? The open meeting hasn't started yet. So you would need to put it on your meeting notice and your agenda. So I wouldn't rely just on your agenda to comply with that part of the statute. So let's see here. We are a board of 3. What is allowed in communicating with another board member as 2 members communicating as a quorum? Let me see here. I thought, I'm just going to scroll through here a little bit. Okay, we're going to talk about that in a couple slides. I'll get to that question. about quorums and what to be careful with there. Are those statutes to be quoted in the CC&Rs usually? No, usually they're not. The statutes are just, they're there, and you just kind of have to be familiar with them. I think most of your managers know this, and they're going to put it on your stuff. But just know it's one of those, either 33-1804 or 33-1248. If an owner brings up their financial situation, violation, whatever, in open session, can we then discuss, especially if they want to? I would say you could. Remember, you don't have to go into executive to talk about these things. It is highly recommended that the financial stuff be brought up in executive, but that's because you don't have permission of the homeowner to air their dirty laundry. If the homeowner is okay with talking about their collection situation or their violations, by all means, talk about it with them. But I would only do that if they want to do it, if they tell you it's okay or they bring it up first. So now, closed meetings. I've already talked. I do this sometimes where I'll jump ahead. But remember, you have the right to go into the executive session. That doesn't mean you have to, but the exceptions in my mind would be anytime you're talking about attorney-client privilege information, or this litigation or the personal information of a homeowner. I would always do that in executive session. And especially the attorney-client privilege things, because the minute you disclose a legal opinion to someone who is not on the board or the manager, you've now waived the attorney-client privilege and you can't bring it back. So as soon as it's disclosed, if anyone wants to get their hands on that opinion, we are going to have to turn it over. There's no longer a privilege that prevents us from keeping it hidden. So if you get an opinion from a lawyer, I very rarely will ever authorize my clients to, or authorize or give the recommendation, I should say, to disclose my opinion. A lot of times an opinion, the reason you're getting that is it's going to have a lot of give and take and a lot of what ifs. And a lot of times it's going to spell out the risks that the association has for doing certain things. Homeowners don't need to see that, because that's just going to drum up a lot of unneeded, unwanted interest or concern that's probably not even founded. It's just they're the what ifs of something that may not even happen yet. So keep that stuff protected at all costs, really. All right, this goes back to the question before. I'm going to throw everything up here on the screen. Very, very common question about emails. What do we do about emails? It's very convenient. We just want to talk about things via email. I'll give you the legal opinion that I give. Now, this is where you could line up 6 attorneys and get 6 different answers. Generally speaking, I think most of us are sort of on the same page with this. That if you have an email communication going where all the board members are participating, all of you are hitting reply all to the emails, I don't see a difference in that from meeting in person and having the same discussion. In my opinion, that is a meeting. You have a quorum of the board, you're discussing association business, and you didn't notice the fact that you were going to have an email communication. You didn't tell the rest of the owners that in 48 hours we're going to hold an email conversation and talk about association business. So if it's stuff that should be in open, and even executive that should be noticed, if you're going to do emails, I would avoid the reply all. If you need to have a response maybe back to your manager about a certain decision or a certain issue, maybe an agenda item, just try to avoid the quorum. Try to avoid the group that makes it a quorum by avoiding the reply all. And it's hard. I get it. It's very easy to want to do this. But and I just had a question, what statute? There is not a statute that prohibits emails. What the statute says in those 2 statutes I've quoted is that the statute applies when you have a quorum of the board that is together discussing association business. And I can get you the citation here. Let me just pull up 1804, and it's going to be in the same place as the other one, in the other one here. But it's 33-1804, subsection E is an elephant, number 3. So 1804 E3 talks about this idea of if you have a quorum of the board that's discussing association business, you have to have noticed it. You can't have that meeting without notice. So the question I think was, let me go back up to it real quick. Whoops. We're a board of 3. What is allowed in communicating with the other board members? Well, if you're a board of 3, if 2 of you are talking, that's a quorum, because now you have a majority of the board that's meeting. So that's tough. So I will tell you that this is one of the most commonly violated parts of this statute because of the convenience of it, because you may not even plan to talk about it, but a quorum of you are together and you just happen to start chatting about association business. It happens. And all I can really tell you is you just need to do your best to avoid that. A homeowner could challenge a decision. I mean, if all you're doing is just discussing maybe general ideas of the association, technically it is going to probably violate the statute. But if you're not making a decision, signing an agreement, things like that, then I'm not sure there's a whole lot of harm. I can't advise you to go ahead and do it, but you need to do your best as a board to follow this law, because it's an important one, and there's like I said, there's a policy statement that says everything should be open. And this goes to this impromptu meetings as well. You may just be at the pool and all of a sudden there's a quorum of you and you start talking about association stuff. And that's a violation of the open meeting laws. So be careful with the open meeting laws, and especially with those emails. Before I talk about committees, there were a couple questions here. Let's see, are those statutes? Let's see, where is it here? I scrolled up too far. Will you speak to daisy chain emails to get around open meetings? I will. Full disclosure, I don't know what a daisy chain email is. If you want to, Lance, if you want to maybe type that in a little more detail in a comment, I'll try to address that. Does this apply to architectural applications? So we're going to talk about committees here in just one second. Can votes then be taken on items via email? So again, we'll talk about that in the next slide. There's a way to take action outside of a meeting that we're going to address. So what about committees? So architectural committees, landscape committees. I've had communities that had the front entrance sign committee because they had enough people that were active that they felt like they needed to give them something to do. So they formed a committee to just govern the front entrance sign. The key with committees is that if they are regularly scheduled committee meetings, meaning that you know that the architectural committee is going to meet every Tuesday of the month, every first Tuesday of the month at 5 o'clock. Okay, that's a regularly scheduled meeting. If they are regularly scheduled, they are bound by the open meeting laws. But if they don't meet on a regular time, and the example, the question here was architectural applications, you have the legal defense here, the argument that you can meet to discuss that without noticing the meeting. The committee could. So the key is whether or not the committee meetings are regularly scheduled. And that'll dictate whether you have to abide by all the rest of this. So again, though, remember that policy statement about open meetings. It is the best practice to always meet in an open setting when possible for those open meeting discussions. But sometimes things happen where you need to, maybe that can, like you said, the committee needs to meet to discuss a certain item, and we're not going to notice the meeting, and that's okay. So now and it's a good comment here about discussing things on email and reply all the time. I fully understand. I mean, it's emails, that is the way things are conducted right now, and that's discussions that are had. All I'm saying is that the way the statute is written, it does say if a quorum of you are discussing this association business, then a notice for that meeting is supposed to be given. I think every community is going to violate this and have these email discussions, and it's probably not something you ever have to really worry about. But you just need to be aware of what the statute says, what someone could argue against whatever you're doing via email. So just you got to try to kind of keep that in mind. So does this also include text message communications between board members? I think it would. What's the difference between text messaging and talking in person? You're communicating with another board member. So if you have a group text with all the board members on it, I think an argument could be made that that's the same thing. So, good question on the texts. Yeah, voting on stuff. So let's talk about this meetings or actions outside of a meeting. Actually, that's minutes. Okay, I'm going to come back to minutes because there's enough questions about this. I want to talk about this quickly. So under the Nonprofit Corporation Act, there is language that allows a board to take action outside of a meeting, outside of the open meeting requirements. What's required for that? Well, there's two requirements. One, it has to be unanimous in the vote. So all three of you, all five of you, however many are on the board, have to vote in agreement. And it has to be in writing. Email's fine. So if you would have to compile those emails saying, I vote for this, I vote for that, I vote for that. The statute allows you to do this, and you're protected in doing this. And this is that fine line that I think a lot of boards run into. So if you are making decisions via email, as one of you commented, if you have a unanimous written consent on a decision, you have a defense to that. The Nonprofit Act says you can do that. My advice, though, is don't make a habit out of it. Don't get, I mean, it's very comfortable and easy to do it that way. You don't want to do it too often is really what it is. And I really would try to limit that. I think I put on the handout here maybe some examples of when to do it. And I think I say, let me see here. Yeah, emergency issues, things that can't wait, or maybe an executive session item that needs to be discussed and voted on. I mean, if you're discussing a landscape contract, I would not do that via unanimous written consent. You really should try to have a meeting, because the homeowners, it goes back to that policy statement. The homeowners should have an opportunity to hear that discussion and participate in the discussion at a certain point. And doing everything via email, I think, flaunts the rules and flaunts the policy that the statute has put in place when it comes to open meetings. So be careful with the emails is what I'll say. But there is a way to act outside of a meeting, and that's what's on the screen here. Now, someone explained to me what a daisy chain here is, and I apologize, I didn't know what that was. Daisy chain telephone calls, emails happen when one member of a board calls and gets decisions from some or all of the board members. Can occur when a community manager calls the board members to get a decision outside the open meeting. One or more persons assembles the vote for a decision. I don't remember the Terry Goddard part, but again, I think I've kind of addressed this, that having maybe one board member talk to another board member, that's not quorum if you have a quorum, five member board. But again, it's what you're allowed to do, actions without a meeting, which is permissible, versus what you should do with the policy statement that says things need to be done in open. Now, formalizing your agenda, figuring out what's going to be discussed at the meeting, I think that's probably okay to have that discussion together, because you're not, while you may be discussing association business, you're not making a decision. You're just trying to figure out what's going to be on the agenda for the meeting. But again, I'll say it again, the stuff that's to be decided in an open meeting, it really needs to be done in the open meeting when a quorum of the board is together to discuss it. So let me go back up here to the minutes. Let me see if there's anything else here. Yeah, so informational emails to help facilitate discussion. I think that's probably okay. It may be seen as a technical violation of the open meeting statutes, but there are certainly a whole bunch of arguments we could make in defense of that. You're not making a decision; you're just preparing for the meeting, and okay, let me go on to minutes, because there's a question about the minutes here, and I'll try to address the other questions. So minutes, as you all know what minutes are. It's the record keeping of the board meeting. There are some practical takeaways about minutes. There actually is nothing in the statutes that requires you to take minutes. Surprisingly, it doesn't mention that in the open meeting laws. You should take minutes. You need to have a record of the discussion, not the discussion, the decisions that were made, just for historical purposes, to defend what was done. It may come up a year later. Why was this decision made? You pull out the minutes and you might have an idea of what was going on at that time, or a decision that was made, who voted on it. You really need to take minutes. And that includes open meetings and closed meetings. Remember, with your closed meeting minutes, they should be brief. They shouldn't go into a whole lot of discussion, and they should be separate from your open meeting minutes because they're protected. You don't have to disclose executive session minutes. That's one of the protected records. But the thing with minutes, keep in mind, is they shouldn't be lengthy. The purpose of your minutes is to just capture the decisions that were made. Who made the motion? Who seconded the motion? What was the vote? If your minutes have things like, well, Tammy said this and then Joe responded this way, cut that stuff out. You don't need that in your minutes. It's not really appropriate for minutes. I mean, I've seen minutes that are multiple pages long, and they really shouldn't be longer than a couple pages at most. It's not a recitation, a regurgitation of everything that transpired at the meeting. It's just to capture the decisions that were made, capture approvals, disapprovals, things like that, for the community. Now, I think the question was, should the meeting minutes be posted on the management site prior to being approved? You can post a draft, but remember, they're not formal minutes until they're approved at the next meeting. So I've seen that come up quite often where the community wants to see it. Nothing said, there's nothing in the statute, like I said, that would govern this. But if you wait to post it until they're approved, that's fine, because they're really not formal until they're approved. But if you meet, like in this question, we meet quarterly, it maybe it's something that you want to post a little quicker than every 3 months. But just, you need to remind them that they're not formal until they're approved, so something might change on them. Can you speak something to feuding neighbors that come to the HOA for help? Yes. I will talk about that when we talk about the enforcement a little bit later. Social media, that's actually a really good one. Social media, engaging in conversation about open meeting topics with homeowners. I don't want to spend too much time on this, other than to say, as a board member, you need to be very careful what you say outside of a meeting. You, as a board member, wear 2 hats. You are a homeowner on one hat. You are a board member on another hat. And depending on your position on the board, someone could try to rely on your statement outside of a board to bind the association to something. I've seen this happen where board member X talks to a homeowner and talks about how great this proposed project looks, that the board member thinks it'll be fine if she builds it that way. Board member was board president, and she relied on that, and that became the subject of a litigation, which we didn't have a court decide. We were able to resolve the case. But you have to be very careful with what you say. So engaging on social media, just be cautious on what you say about items that were maybe discussed, topics that were discussed, because you don't want to be perceived as speaking for the HOA as a whole. Do the decisions made in executive session need to be made and reflected in a regular open meeting? No. You can just keep your decisions in executive session. Let's see. Would you recommend that board members have a separate email for board communications? You know what? That's a fantastic idea. A lot of my clients do that. They will set up a separate Gmail, Hotmail account that is just for association stuff. And what's great about that is I have a case going on right now. It's a big litigation case where the actions of the board members have been called into question, and they did a discovery request for all of their emails for the past 4 years. And we had to turn over a whole bunch of emails, and they had to try to sort through which one had to do with association business, which one didn't, and some stuff was disclosed because we had to, that may not have been had they had a separate email address. So I think it's a great idea if you have a separate email address. You don't have to, but just know that your communications as a board member are records of the association, and people can ask for records of the association. So you need to be careful with what you say. So to kind of keep that your family life, outside life separate, you might want to put a separate email address. Should minutes include the names of members who attended the open meeting and members who spoke? It could. It's not a bad idea. I mean, if you have a lot of people who attend, I'm not sure you want to take the time to go through and get the name of everyone who's at the meeting. or everyone who spoke. But if it's not too cumbersome, it's not a bad idea. And then executive session minutes, I was under the impression board decisions could not be made in executive and had to go back to business. You know, that's a fair question, Diane, and I've had this issue come up where I've had to read the open meeting laws and try to come up with that conclusion of, does it mean that it's just the discussion that takes place in executive session? And I think my advice is that I do think decisions can be made in executive session. There might be something where you just need to discuss a certain private matter that's executive, but the overall decision maybe is okay and open. It really just depends on the situation. I do think, though, that decisions can be made in executive session, like voting on a collection action or voting on a lawsuit, things like that. I think could be made in executive. But I do see that there is, the way the statute is written, an argument someone could try to make that argument that it shouldn't be. But I think you're okay. All right. I want to talk briefly. I know we're about an hour and a half in here. I want to talk about some other practical duties, and what I meant with this were, these are outside of the open meeting statutes. These are some of the other common statutes that you might come across as members of the board. You know, be presented with these facts and decisions. And this might be something you got to kick to your attorney or kick to your manager for the decision. But when you're on the board, you can fully expect to see some of this during your time on the board. And the first thing are records requests. I think every manager who's on this call right now, excuse me, I am sure has seen a records request. I'm sure they've handled a records request for you. Unfortunately, there are some owners out there that abuse this process, and they make a records request every couple of weeks, every month. But we need to understand what this all means. Documents of your association, whether they're financial documents, communications, the governing documents, contracts, whether it's a management contract, a landscape contract, those are all records of your association. Excuse me. And homeowners, excuse me, been talking too much. Homeowners have the right under the statute to review association records, but there are some exceptions. And you look, the statutes that I've put up there on the screen, I think it's in the materials as well. There are certain records that you don't have to disclose to homeowners. So if it's a record that you have to disclose, you have 10 business days to respond to that request. And the response is in one of two forms. Either you have to make it available for them to review in person at some location, usually the management office, or you can send them copies. Well, hold on. You can send them copies and charge them 15 cents a page for those copies. But you have to do one of the two and make those available. And if you don't, that's litigation that can be brought against the community, and the person who brings that litigation can get their attorney's fees and having to do it. So you don't want to ignore a records request. But if that records request involves attorney-client privilege information, pending litigation, or the personal information of a homeowner, you don't have to turn that stuff over, and that's protected. So most of your managers, I think, will handle these when you get them. But if you get a request, make sure your manager, maybe your attorney are helping you out with that, and so that you don't miss the deadline or expose the community to some liability for not responding. Flags and political signs. This also involves real estate signs. There's a whole statute that governs all this, and it's going to trump in most cases your documents. So if someone wants to put up a flag and your documents say no flags, you're going to have to allow it. And there are 5 protected flags that you're probably aware of, but the statute sets forth those flags: the American flag, the Don't Tread on Me, the Gadsden flag, American Indian flag, the state of Arizona flag, things like that. You can't prohibit, and you can create rules that deal with the location of the flagpole or the height of the flagpole, but you can't prohibit a flagpole in the front or backyard. So certain things like that, flags, political signs, and the reason I wanted to put political signs is because we're coming up on an election, and it's an election year. The way the statute's written, people have the right, subject to the local laws about the size of the sign and the number of signs, 71 days prior to the meeting and 3 days after, they have a right to have a political sign in their yard, regardless of what your documents say. So, and in condominiums, they can put it on their limited common elements, and post those signs as well. So be familiar with that statute when it comes, especially as we're getting close to this. We're not 70 days out yet, but we're getting close. Next month we will be. So be aware of that. Parking issues. Parking, depending on your community, parking can be a big deal. Some communities, unfortunately, were developed with streets that are too narrow, and the developer did a poor job of communicating that as they sold the homes. And then you as board members are stuck with angry homeowners who are not allowed to park on their street, or have to park in their garage, or whatever it might be. Your documents are going to govern parking, and that's what you're going to want to look to. But remember, the statute does permit, and this is in the Planned Communities Act, it does permit certain vehicles from being parked on the streets in your community. And those are emergency vehicles and public utility vehicles. You can't prohibit the parking of those vehicles on the street. And then one other thing to keep in mind with parking, if you have amended your CC&Rs since December 3rd or after December 31st of 2014, and you have public streets, you are no longer allowed to enforce parking on your public streets. Now, when I say amended your CC&Rs, if you amended your CC&Rs for some other reason, maybe to address an assessment issue or some other use restriction, I don't think, in my opinion, I don't think that triggers the statute. If you amended and restated your CC&Rs, meaning you started over and recorded a whole new set, and it was in the last 4 years, now you may have shot yourself in the foot on restricting parking on public streets. So you'll want to look at what kind of an amendment, if you did amend, and it only applies to planned communities that have public streets. But just be mindful of that as well if you're still trying to enforce parking. What defines a public versus a private? Who owns the street? Who oversees the street? So if you're in a community, the association owns the street. It doesn't mean you have to be gated. If you own the street as a common area in your community, that's a private street. You get to dictate as an association what takes place on that street. But if it's controlled by the city, the county, whatever it might be, that's a public street. So yeah, that's a good question. It doesn't mean it has to be gated. You just have to own that street as an association. What about permanent flags, not just temporary ones for the 4th of July? If it's one of those 5 flags I mentioned, they can be up at any time. Now, the American flag, most of you probably know this, there are guidelines of how you're supposed to fly the flag. They're bound by that, coming down at dawn or at sunset, things like that. But if they want to fly that flag every day, they can fly it every day, as if it's one of those protected flags. All right, architectural committees. This is for planned communities only. You can see the statutory reference there. The takeaway here is that board members, architectural committees, they are required to have at least one board member on the committee, and that committee, that board member has to chair the committee, has to be the chairperson of your architectural committee. That's really all I have to say about that, but it is a common issue I see come up where planned communities have these architectural committees and don't realize that at least one of those members of the committee has to be a board member and chair the committee. So keep that in mind if you have an architectural committee in your planned community. Yeah, let me see if I put this on the handout for those who don't have the handout for flags. 1 second here. So it's the American flag, the POW flag, the state of Arizona, the Arizona flag, the Arizona Indian Nations flag, and the Gadsden flag, which is the yellow flag with the snake on it. Those are the 5 protected flags that you are not allowed to regulate against. So if they've got their favorite college football team, maybe the Arizona Cardinals, those aren't protected. If you have restrictions governing flags, you can deal with that all day long. It's those other 5 that you cannot regulate, I guess, in your community. All right. Oh, good question. Architectural committee for condos. There is no statute in the Condominium Act that governs architectural committees. So no, a board member does not have to chair the committee in a condo. If you have an architectural committee for your condo, a lot of condos don't have those types of committees, but if you do, there is no statute that governs that. So unless your documents state otherwise, nothing to worry about there for the Condo Act. For sale, for rent signs. I didn't put that on there. Good question. I should have. I just was trying to kind of keep it a little brief. There is a section here. Let me just pull it up here. Basically, what it says on for sale and for lease signs is that you cannot dictate the type of sign they use, as long as it's an industry approved size type of sign. You have to allow it. You can't charge an extra fee for them to use a certain sign. You can't prohibit them from posting the sign. And they have to be allowed to do that. And it's in the, let me see here, I'll get you the subsection. Yeah, so it's for the Planned Community Act is 33-1808, section F. Talks about for sale signs, for rent signs. It talks about the size, the combined size of those signs. It does discuss temporary open house signs, and that you can't require a certain use of that. And it does discuss open house hours. I don't want to get into too much detail, just in the interest of time. There's some other stuff we want to get to, but that section F there, and there's a corresponding section in the Condo Act. You'll want to look at that and review that for real estate signs. Question just came up here about how about a sign for Black Lives Matter or a flag? How to address this? First, I will say there is nothing in the statute that talks about this. Okay, this issue is once you get outside of those protected signs, protected flags, now you're just dealing with what do your documents say, and the documents might say that you can prohibit certain flags at a certain time, and that's a decision the board's going to have to make. And I will tell you, this might come up with you might have the Black Lives Matter flag, you might have a rainbow flag, you might have some other flag that is probably more prevalent during certain times of the year, or certain events have taken place in the country that would warrant that. All I will say is just be consistent. Certainly you don't want to target certain flags or certain signs because you don't agree with it. If you're going to prohibit flags, you got to prohibit all of them. And if you start making exceptions, you could open up a slippery slope there. So nothing in the statute that says that those are protected in any statute I'm aware of. But again, you can't regulate it unless your documents allow you to. And then that's a decision you'll have to make on whether you enforce that or not. So there's a long question here. Let's see if I can just skim through it real quick. Talking about mailing ballots in accordance with Arizona law, may vote in person or mail ballot. A nonprofit corporation, Stacy Association shall provide for votes cast in person and by absentee ballot and some other form of delivery. Actually, the statute you cite there is actually the Planned Community Act, the 1812. When it comes to voting and technology, so the statutes require this. I don't want to get too sidetracked here, but the statutes require that you provide for absentee ballots and that you allow voting in person. But it also says you can allow for voting by some other means. And that some other form, which is provided for in the Planned Community Act and Condo Act, you don't have to have anything in your bylaws that state that, and it would trump your bylaws in that case, that provision of the statute. So you regardless of what your bylaws say, your statute on absentee ballots is going to govern, and you have to allow for absentee mail-in ballots in person, which is very difficult right now with the pandemic, and some other form. A lot of my clients are going to a text to vote, online voting method. There's companies out there now that are targeting associations for this, and there's some good options out there. That would be kind of the other form of delivery to submit your ballot. but you still have to provide for absentee and for voting in person. So let's see who asked that question. If we want to maybe talk offline or on a side conversation, if I didn't answer that question, please let me know, and we can do that. So anyway, and you know what, that's the comment about sports teams on game day. It's one of the flags are interesting. I mean, you don't want to get carried away, I guess, on regulating your flags, but you can if your documents allow. Just be careful with that. Don't get too carried away. All right, enforcement options. These two areas I could take up a whole hour on. It's a separate class that we actually teach, but I wanted to briefly talk about it. And like I said, I'm going to keep this part brief because I don't want to go too long on this part. But when you have all these restrictions we've talked about, you have your CC&Rs, there's going to come a time as a board where you're going to have to make a decision on whether or not we're going to enforce a certain provision in your documents. Or maybe we can grant a variance and allow a certain thing to happen or to occur. Your documents, if you read your CC&Rs, there's going to be multiple references to the word shall or may. One being you don't have an option, you have to perform a shall, or may, you have discretion. When it comes to enforcing, most of your documents will give you the discretion to enforce or not to enforce. And that comes down again back to your fiduciary duty. Is this in the best interest of the community? And is it in the best interest to spend the money to enforce this provision? There are different ways in which you can enforce. And the four under the enforcement, on the enforcement side here, the four most common ways are fines, self-help, suspending their rights, or a lawsuit. Fines is probably the one you're most familiar with. You have your enforcement policy, you send out your notice, you give them an opportunity to be heard, and you impose a fine consistent with your schedule of fines on your policy. Fines have to be reasonable. You can't, if you want to impose a $500 fine for a trash can that's left out, I don't think that's reasonable. But if you have a $500 fine because someone's violating the short-term rental provisions of your documents, I think that's reasonable, because if you give them a $50 fine on a short-term rental, they'll just pay the fine and they'll keep renting their house. It's not discouraging them or I guess encouraging them to abide by the restrictions. So what is a reasonable fine? There isn't a good answer to that. It just kind of depends on the type of fine. I've written policies for my clients that will have a chart that has different types of violations with corresponding fines for that type of violation, and that fluctuates. So it just kind of depends on the situation. But if fines aren't working, you might be able to do self-help. Now, some of you may know what this is, or maybe you've not participated personally, but voted to do this. This is something that has to be in your CC&Rs. If you do not have this in your CC&Rs, you do not have the authority to conduct self-help. And what I mean by self-help is you vote to send someone onto someone's property to fix a violation. Maybe it's weeds, maybe it's a structure, maybe trees need to be trimmed. And you send your landscaper on there to do the trimming, and then you try to pass the cost back to the owner. That's okay if your documents allow you to do it. And when I say documents, your CC&Rs allow you to do that. So before you do self-help, make sure you and your manager and your attorney have reviewed that, and you have the authority to do it. Now, I will say one other thing on that. Just because you have the authority to do it doesn't mean you should do it. In my opinion, the only time you should be considering self-help is if the house is vacant, or maybe it's bank owned after a trustee sale, because homeowners don't understand this and cops don't understand this. I've actually had managers before and landscape people who have been cited for trespassing when they had every right to be on their property, and the cops were called and they were told to leave. So it's not something I think that should be done all the time. I had a community one time that wanted to do self-help to tear down a clubhouse in someone's backyard. And the manager called me up and said they were going to do this. And I had to spend quite a bit of time that day to try to convince them this is not a good idea. You should not do this. And I was successful in convincing them to not go into someone's backyard and tear down a structure because it wasn't approved. So it is an option. Doesn't mean you should do it all the time. So be careful with that. Suspension of rights. Now, I think you could all agree that if you suspend someone's right to vote, it's not going to do anything. I think most people in your community could care less if they have the right to vote or not. but some might care enough about it. But if you have some amenities in your community, maybe a nice pool, a clubhouse, and you have the right to suspend their access to those amenities because of some violation or failing to pay assessments, that can be a very effective tool to bring compliance, especially in the summertime if it's a pool. I had a community one time that had private gates and clickers that were assigned to every owner, and we were able to disable the clicker because he was delinquent in the assessments. And having to roll down his window and talk to a guard was incentive enough for this guy to pay his bill and get his clicker back. So again, that's all driven by what's in your documents and what rights you have in your documents when it comes to enforcing. And then if none of that works, if you've tried everything else and the problem is bad enough that you can't ignore it, then the last ditch effort would be an injunction lawsuit. And that would be a lawsuit we would file with the court and ask the judge to order that owner to comply. And if the owner doesn't comply, then they're in contempt of court and they can actually be arrested for that. And I've seen that happen as well. So that is a last ditch effort though, because enforcement in lawsuits, injunction lawsuits are very timely and very expensive for a community, and it can be a real messy thing. So I don't usually recommend those at all unless you've tried everything else. Defenses we've talked about when it comes to enforcement. Again, this goes back to being consistent, being fair and reasonable. You can't target someone, and so you need to treat everyone the same. And you might get a request sometime to allow something that would otherwise be a violation. For example, you might have a no pet policy. Someone wants to have a dog because it's their emotional support animal. That brings in the fair housing that I mentioned there. And we could spend a lot of time on fair housing, but just know that if someone makes a request under fair housing for a reasonable accommodation, your next phone call should be to your manager or to your attorney for the community about how to proceed, because those can be very difficult. And there's a lot of pitfalls you can step in with fair housing. Collections of assessment, I just laid out the two common ways that attorneys or management companies will collect assessments. A personal money judgment, it's just kind of a standard breach of contract lawsuit that sometimes we have to file. And then a foreclosure lawsuit where the association has a lien on the property and you can foreclose on that lien as a way to try to collect. And then excess proceeds, that happens when a bank forecloses. And let's say that the owner owed $200,000 was left on the mortgage, and the property was sold for $300,000. The bank gets paid their $200,000. There's $100,000 just sitting there. What do we do with that? Well, the association can make a claim for that and get paid whatever they're owed, because they still have lien rights or rights to the money that was there as part of the excess proceeds. So I don't want to talk. If there are any questions about that, you can get my email and shoot me an email. I'll try to answer those questions, but I want to move on quickly here. Let's see. Just, do you feel that increasing the dollar amount of fines depending on the number of notices is defensible? I do. The policies that I draft will start at maybe $25 and increase to 50, maybe increase to 100. I don't see anything wrong with escalating the fines if the violation is continuing to happen, and so long as you've provided proper notice. I think that is defensible. And then it says the board can sue or foreclose for violation assessments. Okay, I'll address that real quickly. No, you cannot foreclose on a fine. And when you say violation assessment, I don't know if I'm assuming you're referring to fines. There are documents that will allow you to impose what's called an enforcement assessment. So costs that you spend to bring someone into compliance could be put on the account as an assessment. That's an assessment. You can foreclose on that. But if we're talking about fines, violations, or fines for violations, those are not part of the lien that we would foreclose on, and are not included in a foreclosure lawsuit that we file. Just be mindful of that with fines, because fines can be hard to collect, because unless they voluntarily pay it or you sue them personally for it, the owner doesn't have to pay the fine. So, and you're not going to collect it at closing typically. Sometimes you can kind of sneak it through, but it's not part of the statutory lien that you have against the homeowner's property. So I want to move on here. There was a question that came up earlier. What do we do if a homeowner or if a board member just doesn't care, doesn't follow the rules, discloses confidential information, and is just kind of a pain in everyone's side, right? We refer to those as rogue board members. And you may have heard that term before of a rogue board member. That is someone, I think I maybe have it on the next slide here. Yeah, a rogue board member is one who acts outside of the scope of their authority, or in a manner that is in opposition to current board policies or decisions. Big picture here, um, I think everyone can agree that your time on the board, you're not going to agree with every decision that's made. You're going to have disagreements with other board members. But as board members, you have to understand that there's a process of doing things, and you have to respect the decision, or accept, I should say, the decision of the majority on the board. If you're in the minority, that might happen. That's fine. But you can't then make it your mission to trash the decision or to go against the decision of the board. You're going to find you could find yourself in hot water for doing that. I think that's a fiduciary duty issue. You need to accept that decision. Now, you may not agree with it, you may not like it, but you know, you note that on in the minutes. You get on the minutes that you don't approve of the decision, and then you move on and you go to the next issue. So you don't want to become a rogue board member that now makes it your personal mission to destroy the association or destroy the rest of the board, or act in contrary, because that is a rogue board member. So what are some options in addressing a rogue board member? There's a couple that I'd like to talk about briefly here. There are, and again, but when I talk about rogue board members, this applies to any board member, any officer, whether it's the treasurer, president, vice president, anyone can be a rogue board member. But what can you do? So let's talk about some things that you might be able to try. Can't say that any of these will be successful, because rogue board members can be very tough to deal with and address. So some of you may have a code of conduct in place in your community. Codes of conduct are documents that are just created to try to set forth the expected duties, behaviors of the board. If you're on the board, you're expected to act a certain way, hold yourself out professionally, treat others with respect. There can be all kinds of things on a code of conduct. And I've mentioned here, it addresses some of the stuff, the duty of confidentiality, duty not to interfere with association operations. That's actually a pretty common one, where a board member will take it upon herself or himself to go out and interfere with a contractor as they're trying to do their work, or to continue to hound the manager or the attorney, things like that they don't have the authority to do it, or it's just wasting time and money. Though that could be an example of something that you address in a code of conduct. The problem with codes of conduct is they're not very enforceable. You could, as your code of conduct, if you could have something in there that says, if you violate this, then you'll be asked to resign. Or you might try to subject the person to fines. I'm not sure about that one. I have seen it. That's why I put it on there. I don't think that's a great idea. You might be asked to leave the meeting, but you're not going to physically force this person out of the meeting. Or they might be subject to legal action. Maybe you have a way to sue them over this for violating the code of conduct. But at the end of the day, you cannot get rid of a board member for violating a code of conduct. The simple fact that he or she violated the code of conduct is not grounds to tell them they are no longer on the board. And so you have to try to find a workaround to deal with the fact that they're still going to be on the board, and how do we continue to operate with this person on the board. It might be that you need to provide some education. And I think that might be in my next slide here. Yeah, so you might have some training, which we'll talk about, but it's difficult. I don't have a great answer of how you deal with rogue board members, because I've seen different things work. You just do your best to try to explain the situation. Maybe you have an attorney write a letter to the board member. There are different things you can try, but when it comes to codes of conduct, they can work, but you can't force a board member to sign it, and it really may not be enforceable at the end of the day, and it's not going to allow you to kick someone off the board. But so attorney involvement, you might have a board training like we're doing right now. Maybe there's someone on this call that has learned something from that, and might be able to take away from this ways to handle this, or maybe ways that they should behave or shouldn't behave. I have had situations where I've actually had to hold a special training just for one board, where I didn't say that we were there just for this particular person, but it became clear pretty quickly that we were there to address this particular board member's actions. But we had a really productive conversation, and he was able to explain his concerns, and we were actually able to find some middle ground, having just a separate executive session type board meeting where it was just the board and the attorney and the manager, and we were able to get some things accomplished to help the situation and help people to understand how the other people were feeling. The other way is, and I've had to do this, is where you have to send a letter to the board member to tell them to cut it out. And I've actually done multiple letters like this in the last couple months to certain boards where you remind them of their fiduciary duty and you tell them that if they continue to do this and they damage the association, there may be legal claims against them, and you try to educate them that way that they need to stop what they're doing. So that may work that way. And then the other two ways would be you can ask them to resign. The board can vote and just make a decision. We'd like you to resign, but they don't have to. They can say, no, thank you. I'm going to stay on the board. And there's nothing you can do about that if they tell you they don't want to resign. You know what? And then a question came up, but it's a great idea that I should have put on the slide. And so I want to talk about it. Remember as board members that you are directors, meaning you can't be removed as a director unless you go through the process, which we'll talk about, but you're also officers. And so you could be the president, the vice president, the treasurer, the secretary, or some other officer that you've created. Those are at the will of the board. Those can be decided by board members. And I had this happen in a community many years ago that the board president would sit at the meeting with his wife. His wife was not on the board, but they would run that association like it was their little kingdom. And she would get involved in the decisions. She wasn't on the board. And the other board members were just kind of at their wits' end. What do we do with this person? Board president went on vacation. While the board president was on vacation, the other board members called a special board meeting with 48 hours notice and voted to remove him as the president of the board. And they called a new president of the board, which they had every right to do under their bylaws. And so the board president came back. He was no longer the board president, and they had a whole new structure of leadership on the board. Well, long story short, that board president threw a fit, actually wouldn't turn over the information for the website, turned it into an anti-HOA website while he was still on the board. It turned into a giant mess. But there might be a way which you can change the officer as a way to maybe take them off of the treasurer role to get them away from the finances, or there's a way you could do that to change that up, and hopefully that, or maybe that will fix the problem. But at the end of the day, the only true way and the only effective way to deal with a rogue board member so that they're no longer a problem would be to have them removed. And the only way to remove a board member, short of them resigning, is through the statute. And there's a statute in both the Planned Communities Act and the Condo Act says the same thing. There's a process you have to follow. And when I say you, I'm talking about the community, where you have to solicit, a petition has to be circulated where a certain percentage of the community has to sign it, depending on how big your community is. And it's 20% or 10%, depending on the size. And then assuming you have enough signatures, then you have to hold an election where a ballot goes out to vote yes or no for the removal of one or more of the board members. And the quorum requirement for that is it's a 20 or 25% quorum requirement, and then it's a majority vote. So if you get a quorum at the meeting with ballots, then as long as a majority vote to remove that board member is out, effective of the day of the meeting. And then the rest of the board can appoint a replacement through the bylaws, or another election can be held if enough board members are removed. So a lot of your bylaws will talk about removing the board members. You have to ignore any bylaw provision that talks about removal. They don't apply. You can only rely on the statute for removal. All right, last two slides here, and I certainly appreciate your patience. I know we've run a little bit over the 2-hour mark, but I've compiled a list here of 10 ways that board members, and some of these are general, but it's just in my experience in representing associations for as long as I have, seen all the different arguments that are made and mistakes that are made by board members So these are just some food for thought. No particular order here. It's not in a list of importance. It's just kind of as my mind was thinking of them, I typed them out. So not knowing your governing documents. We've talked about this. If you don't know your governing documents, that's a quick way to get yourself in trouble because you might make a decision that goes contrary to the documents, and it's not going to end well for you. Thinking that you know the law. And this is not some sort of self-promotion to hire me or another law firm. This is legitimate. If you think you know the law, be careful because there are some intricacies of these statutes that that you may misinterpret. And so, I don't doubt that all of you on the call are very intelligent and understand the law, but just be very careful if you think you know it. It might be worth getting an opinion on, as we talked about before. And that goes along this next one, thinking you don't need experts. Remember, experts are there for your protection as board members. They might cost some money, but at the end of the day, it's protecting the community and you as board members from liability by relying on the experts. So don't, if you have to spend a little money to get an expert opinion, it's going to be worth the money because it offers you that protection, that safe harbor that you really need. Acting outside your role. Remember what your role is as board members. Remember what your authority is as board members, and don't act outside of that. Not cooperating with other board members. I talked about this just recently with rogue board members. This doesn't mean you have to get along with everyone. You may not like someone on the board, but you need to try your best to try to cooperate because at the end of the day, remember what your purpose is. It's to do what's in the best interest of the association, and you need to all be trying to work together to get your association to a better place or to help your association to thrive. And if all you're worried about is fighting with each other, you're not going to accomplish that goal. Not preparing for meetings. Do what you can. I mean, I'm sure most of your managers send you out the agenda items ahead of time. Maybe a contract that you're going to be discussing. Take the time to prepare and show up. And if you're on the board, attend the meetings. Some of your documents may actually allow, and this is something I didn't put on the rogue board member because it doesn't really have to do with rogue board members, but you might actually have a qualification in your bylaws that requires you to attend a certain number of meetings. And if you miss certain number of meetings, you might no longer qualify to be on the board. So keep that in mind. You might have language like that. So if you're taking the time to run for an election and be on the board, you should participate in the meetings as best you can. Not conducting professional meetings. You don't have to have a very kind of formal British style, Robert's rules, very formal type of meeting. That's not what I'm saying here. But you should act in a professional manner. Avoid the unprofessional, maybe name calling, insults, being rude to the homeowners that are there. That's a quick way to stir up a lot of hatred in your community, a lot of distrust from the homeowners towards their board, and it doesn't foster any sort of community feeling for you. So do what you can to be professional and courteous. Failing to maintain confidence, as we talked about this, there are some big repercussions that can come from not maintaining those confidence. Making decisions based on principle. This goes back to my comment about your fiduciary duty and acting in what's in the best interest of the community, and this may go against what you believe to be right. And if you want to argue and you want to litigate a case because you are just certain you are in the right and it's just not right that this person's going to get away with this, okay, now you're basing your decision on your principles, and that is not a good argument to make. It has to be based in the law, obviously, in the documents, but is it going to serve the community to do this? Is it going to be in their best interest? So try to avoid the principle of the thing and litigating on principle. And then lastly, failing to enforce your documents. I didn't go into a lot of detail on this on the enforcement, but if you don't enforce your documents, you might lose the ability to enforce them later. You might lose control of your community and the image that you would like it to portray, whether it's in houses that aren't painted the right way or landscaping that's not done. It's very understandable that as board members, you may not feel comfortable suing your neighbor for collections or for painting his house the wrong color. But again, remember, you have two hats that you're wearing here. You signed on for this as board members, and so you have this duty now to act in the interest of the community and enforce the documents. You may not have an obligation to enforce everything, but don't lose control of that. Don't fail to enforce just because you don't feel like it. You want to be nice. Sometimes it's good to be nice. You got to be polite and courteous, and you want to be a good neighbor. But remember too that if people aren't paying assessments or aren't doing it, it affects everyone. It affects the ability for the association to function. And people buy into homeowners associations because they like that sense of community and the cleanliness, just the appearance of things in most communities is much better than those that don't have associations. And that's the value of that. So just be aware of that. Enforcing. And there are other issues that I didn't put on the list. I mean, this is not an exhaustive list, but any last questions here? Let's see. Can you show the slide for the first 5 again? Oh yeah, let me go back on the slide here. Okay, there's the first 5, and I'll look at some other questions here. I think there was one I missed. Let me just go up here. Oh yeah, so there was a question about, can the articles or the bylaws talk about expelling a board member if it's unanimous? They can say that, but it's not enforceable. You have to follow the statute. Our board is currently down to 2 members. Does this mean for now any and all decisions require the approval of both? Yes. If you're down to 2, your majority, your quorum is 2, and only action can be taken by a quorum of the board. So if you're down to 2, you both have to be on the same page, and you both have to vote on it and approve it. So I may have missed some other questions. If I did, I'm sorry. Michelle can get you my email address. I meant to put it on the last slide here, and it might be, I don't know if it was on it may not have even been on the handout. Oh shoot, I forgot to put it on there. My email address is my first initial and last name. So it's QCUPPS, qcups@vf-law.com. And that's it. So if you have any questions, maybe something that I didn't address or you think of after we leave here, just shoot me an email. I'm happy to answer it for you. And again, thank you for your time on this and for, oh, wait, there's one more here, feuding neighbors. Oh, that's right. So there was a question earlier about neighbors who are feuding, who feel that the board needs to take care of the problem. Very common. There are 2 things to look at there. One, you might have language in your CC&Rs that addresses this issue. And a lot of times you will find it in a section that deals with party walls. If you're a community that has party walls, shared walls, make sure you look at that provision, because if the dispute involves party walls, there's a very good chance that they can take this issue to the association for a final decision. Probably not in the planned communities very much, but if it's a townhome, a condominium, be very mindful of that language in your documents. There might also be language in your documents that addresses this issue of, if there is a dispute between neighbors, that they can actually submit this to the board, and the board can be the final arbiter of the issue and can make a binding decision that they all have to live by. A lot of CC&Rs don't have that, but it might be in your community documents. If it doesn't say that, and there's no mention of the association getting involved, it's an owner-to-owner dispute, and and you can tell. I'm just going to put my name in here and you can tell the owners that. You can tell them that, hey, I understand the concern, but that's something you 2 are going to have to figure out. And unless it involves association property or an association obligation, stay out of it. Let them handle it. It's a dispute between the owners, and you have no obligation, unless your documents state otherwise, to get involved. So. Any other questions? I'll give another 20 seconds here if there's another question. And if not, if you'd like a copy of the presentation, if you wouldn't, I'll send the presentation to Michelle at Vision, and probably in a PDF format, and she can circulate it around to anyone who's interested. But thank you again for your time, and I hope all of you are healthy and safe, and have a good rest of your night.
Thank you so much.
Okay, thank you.
Bye-bye now.
Thank you very much.
You're welcome.
Great, thank you. Very good, very informative. Thank you.
Yep.
Thank you. A lot of information. Thank you.
You're welcome.
Leave.